that concerns journalism and very clear processing of an individual in respect of collecting data and then analysing the data for the purpose of journalism. So I'd be reluctant to overly apply that precedent as a general precedent. But I do think that that interpretation of what constitutes monitoring is likely to be broad. I think that any anonymisation, anything falling short of anonymisation as required in GDPR, that very high standard, anything that might be pseudonymization isn't sufficient to get around the temporal scope or the territorial scope, and therefore the GDPR is still likely to apply.
So I would, what I would say is, so the answer is, like, it's still likely to apply, and then the real answer is, I think, and you can correct me if I'm wrong, is that if you're doing it, and again, Dalit was saying, budget and risk and things, if you're doing this, it would be better if you did it and anonymized it. It'd be best if you didn't do it at all and you structured your data collection such that it doesn't fire in the EU at all. But if you did it and then if you have it, but you're taking steps to shut it down, I think even if legally GDPR applies, I think it probably decreases the likelihood of your likelihood that you are going to be the case to be enforced against, right? The more steps you take to narrow down the actual collection, it's not foolproof, you heard it, don't do it, but if you already did it, it's better to,
I think we have to add something else here also, that the fact that you're telling people don't give me your data does not give you the exemption. So I think maybe it could have been misunderstood from the discussion. If you get the data, you have the data.
Yeah, no.
So you have to comply because it might have been misunderstood.
But I'm saying if you have your tracker and you aren't able to not have your tracker, but you're taking steps to limit the data collected, not say, hey, I have Google Analytics, but I don't really care. It's like you're taking tech steps. If they're not perfect, that's probably better than nothing.
I'll add for the Israelis, I'll add the additional layer of the regulation of data that's coming from the EEA. We talked about being infected by the GDPR, so maybe you're not too concerned about the CNIL, but remember that data is also coming via Google, Facebook from the EEA to Israel, infects your data in the regulation.
But only for 4 specific issues.
For 4 specific issues, but the regulations give Israeli data subjects, new rights, which I'm sure they will use. So it's certainly lots of potential for trouble. And I think Dalit is now going to show us how much trouble you can get into in Israel without the e-privacy directive at all, without the GDPR. I mean, our law is from 1981. It doesn't even say internet, right? Cookies, new. When they enacted it, they thought there'd be 200
You call it
databases.
Technologically neutral.
Yes.
It's future-proof.
It was technology less rather than technology neutral.
So I think the discussion until now was sort of based on the obvious assumptions that we didn't even stress that technological data or online identifiers are personal data, which was the underlying assumption we didn't even need to mention, because for anybody here practicing GDPR or coming from the EU and now also from the US, that would have been obvious. So I think I have to start by saying that the definition of personal data under Israeli law is very, very limited. Again, under the law from 1981, it has been expanded in case law, and it has been expanded in many opinions, guidelines, documents, all kinds of documents from the Privacy Protection Authority. But still, I think the underlying assumption that says that an online tracker equals personal data in Israel is still a question mark. Because the law is still the law, and there is a limit to what you can, let's say, pull it into to transform it in what you can do with interpretation and case law. I have to say in brackets that for those that are not aware, there is an advanced bill for the amendment of the Privacy Protection Law. It's called Amendment 14. It has been discussed in the previous parliament, and it has been granted a continuity status. It's going to be discussed in the current parliament. And under that bill, there is an amended definition of personal information, which is more or less equivalent to the personal data of the GDPR. So I think that if we had Amendment 14, sorry, we were talking this morning a lot about Amendment 15, so I was, so if Amendment 14 had been adopted, I think the first building block of what do we have to do for cookies in Israel would have been solved in the sense that I think online identifiers could have been classified as personal data without a question mark that exists today. The other element is that under Israeli law, the only legal basis apart from a legal obligation is consent. And consent under Israeli law, and this is again the text of the law, as long as it is informed, it can also be implied. It does not have to be specific, unambiguous, and all of the buzzwords that Eyal quoted from the GDPR. And Mira's nodding, you can barge in and you can interrupt, but
I'm not sure whether it doesn't have to be specific, but
it has to be informed. The informed has to be specific. Once it's informed, then the consent can be implied.
It can be implied, but in our perspective, it should be specific. It could be specific.
So you stick it
in an implied way. I know it's.
You stick it in section 47 of the privacy notice, but it's a really long section.
No. To their benefit, I have to say that the clarification regarding what the informed, under the informed consent means in terms of what notification you have to give have been clarified quite elaborately last summer, I think in August. So there is a document explaining what you need to inform data subjects in order for the consent to be valid, stating specifically that if you do not comply with these guidelines, then you may be risking unlawful processing because the consent would not be lawful because the notification was not intact.
But does it have to be just in time, or can it just be in the privacy notice?
The guidelines don't say how it has to be given, but it has to be before you give the data or combined with the consent process. So it can be before you provide consent or combined with the consent process, as long as when you are consenting, the consent is informed. And that's, by the way, the text, the original text of the privacy protection law only had consent as implied or explicit. And the word informed, meaning that you have to have a proper notification, was added to the definition of consent at a later change. It wasn't the original text of the law. And coupled with that is we have section 11 of the privacy protection law, which does say and has said all along that you need to inform data subjects what data you're collecting, what you're doing with it, who you're sharing it with, and so forth, and if they have a legal obligation to give you the data, or it's based on their consent or their free will. Yeah.
Excuse my ignorance, but is there some sort of consensus between these different bodies as to what constitutes personal data?
So it depends on the jurisdiction. There are things that are obvious as personal data. I think the difference between jurisdiction is that in some jurisdictions the definition is very explicit, like it has examples of including this and this and this and this, including an IP address, including an online identifier. In other jurisdictions, it's just a general definition. And I think the major difference, if I can map it, and again, I'm not purporting to be an expert on all privacy laws around the globe, but it would be the definition between personal data, which in the eyes of anybody, not even a privacy professional, would mean personal data, like your details, your ID number, things that are obvious like biometrics, and things that could reasonably identify a person. And that's, I think, that the tricky part, which is not part of the Israeli current definition, although it is the practice and it is has been added through case law and Privacy Protection Authority guidelines, but it is part of the GDPR definition, for instance. And when Amendment 14, I won't say if, I'll say when Amendment 14 is adopted, then we will also have that same definition in Israeli law. And I think, Odia, you can agree that also the US state laws that have some kind of difference between them, the common baseline of them would be more or less the same. I don't think there would be a lot of debate over what the basic personal data is. Like, it's not only data that clearly identifies you, but it's also data that could identify you maybe with coupled with other data.
So I think to your question, the baseline right now, I think it's like probably what we have in what everybody that uses the term PII mistakenly, but what it's actually meant. PII, personally identifiable information, is the term that used in the US when of what data do you need to notify if it is breached, right? Data breach notification. So like name plus access to a financial account, credit card, health information, health insurance information, right? So those driver's license, pass, like those types of things, right? I think everybody knows. I think this is personal information everywhere, right? Because if that's implicated, it's very obviously identifies you and very obviously can cause harm. The sort of gray areas are, Dalit said biometrics. I think biometrics is common, other than there is a difference in some of the laws, is it biometrics collected to identify you, or biometrics collected and capable of identifying you, but not used for that purpose. There are laws that go both ways in this situation. And then in the new U.S. laws, all of the new U.S. laws, of which we have like 10 going on 11 plus Washington State, they are all greater than or equal to the definition of personal data in GDPR. So they're at least as you could arguably say it's more, because California is like also attributed to a connected device or household. Nobody knows what that is, but you know, whatever.
Alexa.
So yeah, exactly. And like your car, for example, right? Or like your car VIN number, because it anyway. So that's gonna, but it's as broad, at least as broad as GDPR. The difference is, and I'll talk about it, there are some pre-existing laws, like the Video Privacy Protection Act, that talks about pixels embedded in videos, that there is no definition of personal data there, and in the ongoing litigation under that, there are still people, which is like shocking to me, that concurrently with CPRA are saying, you know, a pixel, a device identifier picked up by a pixel is not personal information for the purpose of the law. I mean, I think that's a stretch, and we are already seeing even the FTC enforcement regards, you know, IP address and probabilistic identifiers as personal data. So I think everybody's really kind of coalescing to a very big common understanding of what is personal information. The consequences, once, like you're in scope, the consequences of it, I think, differ between the laws, and there's like a higher standard of sensitive information, there's a higher standard of biometrics, etc. But I think that once you guys have that amendment, I think the baseline is going to be very similar. Yeah.
And basically, we that's what I guess all three of us do on a mostly a daily basis, because the clear-cut cases where you know you're processing personal data are easier. But those cases where you are contemplating whether it is or not personal data, depending on the parameters that you have or that you can cross-reference the data with, is basically what we deal with a lot of the time when we deal with vendor contracts. And okay, we're giving vendor, we're not giving an ID number, or I don't know if it's an insurance company policy number, and we're just giving certain parameters. But then starts the discussion, okay, are these parameters together? Can they make the identification of the individual easier? Can they reasonably cause the identification? And that's a day-to-day, and there's no like school book answer on that, and that's the practicality of it. By the way, Google Analytics, we were talking about it internally. I personally, being a privacy practitioner, knowing GDPR, knowing a little bit about the US case laws, I found that the judgments or the decisions of the EU regulators about Google Analytics surprising in the sense that it was determined that the Google CID, the Google identification, which is unique per website on which Google Analytics is installed, is in itself personal data, even if it's not cross-referenced with other data. So data protection authorities are taking this a lot, much further than we would have thought in the, let's say, old world of what personal data would mean.
I asked that question, I think, coming again from a quantic field space where frequency starts becoming very person specific. And that's, I'm going to go to these the cyberspace to do with frequency, because I want to understand how that interlinks. And so obviously asking the right questions becomes really important. But you've already given me quite a lot of information, because I wasn't aware that it had gone so deep yet, even in the electronics market.
So it's either even that, and then even other things like types of biometrics. So they're like, apparently in Europe there's already case law that talks about the way that you swipe your finger interacting with a touch screen is a biometric identifier. Gait analysis is biometric identifier. Like typing style and frequency is a biometric identifier.
For you, definitely.
And the clicks of the nails are biometric. The like gaze and like the way you're like with I'm reading this book on like neuroprivacy, right? Like the way that you look at the screen and like follow, like all of that is very personal. Even the brain waves apparently are personal. So you can like make.
Shouldn't it be? I
don't know.
There is.
I guess.
Let's say you have recordings of all of your customers, and it used to be just for service purposes, and now you want to analyze whether they're lying, and whether they're to identify them with their voice.
First of all, call your lawyer immediately. Don't do it before you. Yeah.
One thing I would say, and I'll hand it back to Dalit, the European concept of singling out, that is, you cannot really identify the person, so no one is going to knock on your door and say, "Hi, I'm from Google, I identified you through your CID." That is not going to happen, and that is not needed in Europe at all.
In order to be personal data.
In order for it to be personal data, because the mere fact that you can single out that CID is generally enough for it to be considered personal information. I don't think Israel is there yet. When we talk about personal data, we always say reasonably identifiable. Like the new laws that we have that talk about personal data talk about reasonably identifiable.
Yeah.
So Colorado has the word probabilistic in the law, and the FTC uses the word probabilistic in its enforcement action.
Yeah,
so
but does it mean
is
that you
already
need
there.
to be able to knock on someone's door?
No, that's what
No.
I'm saying. Probabilistic. It doesn't need to be deterministic. It
Okay.
could be.
It's again
both.
reasonably
Yeah,
identified.
yeah.
It's a difference.
So they took that.
So if I'm going back to Israeli law and cookies and what we need to do, or what we are obligated to do. So having said that, there is a question mark whether online identifiers as such are personal data. Coupled with the fact that consent, as long as it's informed, can be implied, brings us to what we have to do in Israel. And is the regime in Israel similar to the one in the EU in terms of very, very detailed cookie banners with accept, reject, and choices, and the split of the various types of cookies? Or can we take a more conservative, I would say, or old school approach that says a cookie banner doesn't have to be, it could be a stupid cookie banner, like a simple cookie banner, just saying we have cookies. And also that gets into a lot of technicalities, whether you have to close it, or you have to agree, or it just disappears when you continue scrolling. And regretfully, and this is a challenge to Nir and his team, there is no specific guidance from the Privacy Protection Authority on this specific point of cookies, as opposed to a lot of decisions that were, we talked about here, of the CNIL and other data protection authorities in Europe. The only formal reference to cookies in anything that the Privacy Protection Authority has published is in their, there is a document that was published a while ago about wallet applications, and again, put it in context that wallet applications collect sensitive financial data, so it's not just personal data per se. And in that document from April 2021, the authority says, and I'm quoting, it's my free translation to English, it is preferable that the request for consent to place cookies which are not necessary for the use of the app shall be separate and together with an explanation of the consequences of consenting to cookies and receipt of an opt-in consent. this is based on the Planet 49 EU case regarding the cookie wall and cookie
So I have a
consent.
question. So
So-
in the UK, when you say it's preferable, that means if you don't do it, like you get hanged in the street, right? When you, in Israel, you say it's preferable. That means
No,
it's
but if you
mandatory.
if you
we
heard
live
optional.
in a
Very
different-
non-mandatory.
We live in a different kind of neighborhood, so preferable if you are a public authority, preferable has more meaning.
so that's for the Bureau of Statistics, right?
Yeah,
For example, but
I think
preferable is preferable. generally.
It's like if you heard Reuven's talk before, there are a lot of recommendations like the appointment of a DPO, like performance of a DPIA, a lot of recommendations coming out of the Privacy Protection Authority in various documents. By the way, this document was sort of it wasn't even a policy paper, it was like a very, not a guidance or anything to that effect. But I think it's an indication of what should be the practice, at least for applications that collect more sensitive data, and a reference that maybe just a simple banner is not sufficient unless, and it will always depend on the circumstances, you have the proper notification.
And if
So-
I may add, again, generally speaking, but even if it's just preferable, if the controller is basing his processing on the defenses of the law, so it has legal meaning, because the processing based on defenses, the Article 18 has to be not in so many words, but proportional and done in bona fide, in good faith. So sometimes it may have legal meaning even for controllers from the private sector.
So it's like a secondary offense, like in Pennsylvania, if you have your seatbelt not buckled, nobody can pull you over for it. But if you get pulled over for a busted taillight and you don't have your seatbelt buckled, that's a worse problem.
well, I think one thing when this such a statement from our regulator could be useful is maybe when the question comes to court and like class actions. But the problem is that particular communication was limited to wallet application
And the sensitive data.
and the sensitive data, and basically our regulator says it does not even apply to websites of banks. So this is very, very specific to wallet applications. Do you take that and expand it? I understand it's preferable for all cookies, but this is not what they're saying.
So I think the bottom line would be that if you have a simple banner, or not even a banner, but some kind of clear, distinct notification on your website that you have cookies, it may be sufficient in Israel, and I'm saying may, provided you give the proper disclosures, provided your privacy policy, cookie policy, we don't have that very formal distinction as was developed in the EU, has the list of cookies, and not just general saying we use cookies. You have to say if you're using analytical cookies, you have to say if you're using different types of cookies, marketing cookies and so forth. And specifically, again, if I'm basing this on Section 11 of the PPL, of the Privacy Protection Law, if these are third-party cookies and data is transferred to the third-party provider and they can do something with it, such as Google Analytics, you also have to say that. And if you're, for instance, combining Google Analytics with Google DoubleClick for advertising, you have to tell people that, because it means that it's not within the reasonable expectation. The implied consent principle basically says that if it's within your with your reasonable expectation, maybe the disclosure doesn't have to be that elaborate. For instance, the simplest example I can find is an employee coming to work for a company, and the HR asks him for his bank account details. They don't have to tell him, we need your bank account details because we need to pay your salary. It's obvious, assuming they don't intend to use that data for any other purpose. That's, I think, current with Israeli current law. But for cookies, which are not self-explanatory and are not usually within except strictly necessary cookies, of course, which are not within the reasonable expectation of an individual. You have to give more detail, you have to be more informative. And then also the implied consent principle can imply that you don't really need an accept all, reject all, and choices cookie banner, and a lot of Israeli sites don't have that.
And then we have the client that asked me if it's okay for them to also monitor the bank balance of their employees, because that's expected.
Maybe they want to give them loans.
Speaking about Israeli website, the Israeli website is, very small, what about GDPR? Is it specific enough regarding the banner?
So we will get to that. Although we already have a hint on what's to come if you are subject to GDPR or your website is accessed from Europe. Having heard everything that Dalit says, I would just add one thing. There are currently, I think I lost count, but I think it's 36 different class actions, or rather class actions against 36, maybe 40 now, companies in Israel regarding Facebook and Google and basically tracking and analytics. Recent one just filed last week.
And also cookie consent.
And basically they all say, like in the EU, we need specific opt-in, blah, 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 all of that. So we start from a situation where we don't have the e-privacy directive, we have implied consent in our law, but EU thinking about cookies is certainly affecting at least the mindset of class actions or plaintiffs in Israel.
So the argument is it's the reasonable expectation of the Israeli consumer that GDPR apply.
Not in so many words, yes, but I think that, Eyal, we can also add that from behind the scenes of the cases that we are more familiar with, that I'm saying it cautiously, but I don't expect them to end with a GDPR style decision. So the solution will probably be somewhere in the middle. That's my expectation, at least.
I think the law doesn't support an EU-style banner in Israel, but again, like real life, this is a smart tactic from plaintiffs. You'll get one company that maybe doesn't care about the banner so much, and just make them do like the really good banner EU-style, and we see that in two places. First, international companies. EU headquarters just telling them, put the banner on your Hebrew website and that's that. We don't want to take any risk. And the other is companies like Israel Railways. That doesn't even, I don't think, you cannot even buy tickets there. It's just see the timetable. And yet they have one of the most impressive cookie banners in Israel. I don't know why. I know they were sued, and they're no longer being sued.
So you have to deal with all the toggles while the train's delayed. So
exactly. So, I mean, they don't care. I mean, you don't have another website or another train provider or anything, and they don't sell tickets. So if you want to know when the next train might come, you have to go there, and that's it. So they have really a fantastic cookie banner, even though there's no...
Why do they even, the question is, why do they even have cookies? Because nobody cares, but...
They want to know how many times you check
how many
your
people
train.
Are checking the
how
time,
many times you check your train.
But see, but we can, but basically, see, this is like you're all obsessed about what the law says, and then we have the FTC that just says, hey, we're going to enforce anyway,
without the law.
Without the law, so it's
the
fine.
same in Israel, basically.
So tell us what the US says.
Yeah, exactly, right. So first of all, so in the US it's complicated. I think the bottom line is to like start from the end, right? In the US, you do need a cookie banner. Definitely under the new state laws. Probably also pretty certainly under the FTC jurisdiction, which is pretty much most everybody. I mean, not banks, but like anybody that's subject to FTC jurisdiction. The banner is going to need to be GDPR style in the sense of it needs to be granular and it needs to give you choice, but the choice that it needs to give you is different than GDPR. So that's kind of the summary, and then I'll go into the specifics. So the first thing is trackers are regulated under the new US laws, right? The information collected through through cookies and trackers like the IP address, the IDFA, the device identifier, the device fingerprinting, all that stuff. That's all personal information. So we don't have any privacy directive. It's all governed by the privacy laws. So it's the personal information collected through the trackers. And they are basically saying you have two obligations. Number one is the obligation of transparency, very similar to Article 12.13 of GDPR. The level of transparency requirements under the California law, which is CPRA, and the other 11 are also very similar to Article 13. Not exactly the same as Article 13, but they are similar in the level of granularity. Do you actually need, and Cian, this is actually interesting because I thought the gold standard of cookie disclosure was like the APD, the Belgian APD website, where they have this like chart with purpose data, like cookie, purpose, data collected, retention term. But then I went to other websites, including some of actual EU regulators, and they don't have that. So I don't know if that's because I've been telling clients you've got to do it.
Maybe they don't have cookies at all.
Well, they have. The one that I saw did have very few cookies, so I think it's kind of the moot problem. But I think, by the way, my personal opinion, based on the California Attorney General Q&A and on one of the provisions in the California regs, is that you do need that level of disclosure for California and therefore for the other laws. California has the same language with respect to, similar language on transparency and data retention as GDPR does. And in GDPR, the granular retention has already been flagged. So you need the disclosure piece. You need to have it somewhere, right, in your notice. But you also need to, so here's the thing with the banner, which is the just-in-time. So you need the notice. Do you need a just-in-time notice? I think yes. Why? Meaning a banner-ish type thing. And here, why yes? Yes, because number one, when CCPA came out, there was a Q&A for all of the regs. And somebody asked, do we have to have a banner? A banner is annoying. It's like onerous. And the California Attorney General says, I am not going to tell you that using a banner is required, but it is up to you to figure out how you live up to your transparency requirement without it. So, like, that's, as regulators go, that's a pretty definitive statement, I feel like. So that's number one.
Can you disclose under the, a link in the privacy policy, say, okay, that's going to be,
It's not enough, because nobody knows where to find it. So you need something that says, we use cookies and here they are, or something, right? So you need something that's just in time.
That's
now,
already been a law in the U.S.
So that's what I'm saying. The law doesn't say it. Well, here's the thing. The California says, number one, you need a privacy notice. Number two, you need a notice at collection. And that part's different than GDPR, because GDPR, there is guidance in the EDPB transparency guidance. There is guidance on first layer disclosure, but it's not part of GDPR, it's part of the EDPB guidance. California literally has a section that says you need a privacy notice, but you also need a just-in-time notice that provides you information in real time. The just-in-time notice could be, there are certain circumstances where, unclear, where it could be a hyperlink or it could be text. That part is not 100% clear. So here's, like, I had a client that said, well, our marketing hates the banner. We don't want the banner. What are we going to do with the banner?
Had just one client?
And
all clients
so,
say that.
Yeah. And so the answer here, and I don't know 100% because the FTC is making this difficult, and I'll explain why. But from a California perspective, if you guys have seen, there are certain websites that have a little C in the bottom, or they have a little floating icon that looks like a chocolate chip cookie or whatever. Now, I don't know if you have a floating chocolate chip that when you click it, you have all of the information that you need. I don't know if that's not enough, because it's a just-in-time indication, hey, there's cookies. If you don't care, I feel like you've made a conscious decision to not care. And if you do care and you do one click and you get all of the information and choices, that might be good enough. I don't know, it has not been tested. That's the other problem, is that, first of all, CPRA, we don't have clear enforcement yet, because until now everything was right to cure. So we have anonymous summarized decisions. We have one decision that I'll discuss, which is the Sephora case. And that was interesting, but that's all we have. And then we have the FTC, which is interesting, because the FTC decisions, the problem with them, and that's like well-known problem that has become exacerbated under the current leadership of the FTC, is the FTC enforces, the mandate of the FTC is Article 5, Section 5 of the FTC Act, which says deceptive or unfair acts or practices. Out of those like 5-6 words, there's all of privacy enforcement on the federal level. And that is, to me, when I look at it and compare it with what I know from Europe, it's like, okay, well, that's not surprising. To somebody, it's like, where did you get like 50 pages of stuff out of unfair or deceptive acts or practices, right? And so that there is ongoing like hearings and things. It's not even just in the privacy stuff. There's like a lot of FTC enforcement. The enforcement is not by regulation. There are enforcement actions where you sort of trying to figure out what the operational thing is. They have blog posts where they say stuff, and then they enforce based on the blog post. And so
all those enforcement decisions, they are based on the consent of the company.
Yeah, they're consent orders.
Because
like,
otherwise
yes.
they will be punished on another.
Yeah, the FTC enforces by consent orders, because the FTC is basically it's like an antitrust authority, it's the competition authority. They enforce by consent decrees, so that the company enters into an agreement with the FTC without admitting any guilt, blah blah, or whatever, and then these are like the agreed upon stuff.
So it doesn't
it's not a precedent.
Right.
It's not a precedent, but it kind of is, because you already know what the FTC is thinking. And
It's the same as your recommendations.
So
the recommendation, but we know what you're thinking. We know that that's your expectation.
So we know what the FTC is thinking, number one. And number two, the other thing that's interesting is the FTC Act. There are I think every single state has what's called a baby FTC Act. Their Consumer Protection, Unfair and Deceptive Conduct, UDAP laws. So this criteria of unfair and deceptive act or practice, there are state laws. And you can file class action lawsuits. And the AGs in the states, they also know if the FTC is thinking this is deceptive, I'm going to think this is deceptive too, right? So that's really important. Now, why is this complicated? Because there are 3 enforcement actions by the FTC, recent ones, where the BetterHelp is the key one, where the FTC literally kept cropping the banners that BetterHelp posted and saying, why is it not good enough? Now, they didn't say what was good. I mean, they said what was missing. But they didn't say, oh, you could have achieved it in a different purpose. And BetterHelp is also a little bit of bad cases make bad law, because you guys know what BetterHelp is? It's this online platform for therapy, like finding a therapist. And they didn't share the therapy data, thankfully. What they did share was they had trackers on the website of signing up to the platform. And they had Meta and Criteo and whatever, they had a bunch of stuff. Now, problem A was that they had in 5 different places, we don't share your personal information ever to anyone. That's a problem, because that was not true. And that's the key thing, is the FTC, this is, you lied. You can't say that, right? And so that, and to Cian's point, right, they didn't know, right? Is it okay that they didn't know? No. There was, at the FTC, there's a whole half page where they're trashing the junior marketing analyst that was responsible for setting up the trackers. And they basically said, it's not okay that this is a junior person. It's not okay that they don't know. It's not okay that you didn't train them. It's not okay that you weren't responsible for them. It's your responsibility to understand the sharing. It's your responsibility to know what is in your agreements that facilitate this strict, parentheses, right? The Metapixel agreement, the Google Analytics agreement. And the FTC basically says, not in those many words, but kind of similar words, we understand these are contracts of adhesion. We understand we have zero bargaining power. They didn't say, but we all know. We understand that you may not have a lot of alternatives to do what you need to do with other, providers that don't do this, but your problem, haha. like not really, but kind of, right? Like it's your responsibility. You cannot enter into agreements that facilitate the sharing through the tracker without knowing what is being shared, because if you don't know, you can't tell people, and if you can't tell people, the people don't know, and if the people don't know, it's deceptive and unfair.
Oh yeah, if you don't mind, I would like to ask to you. So, I mean, going down to the practice, we all know the startups need, in general terms, a business model, especially these days. Three years ago, maybe, if you were a startup and you show some capability of bringing users, they will tell you, okay, bring the users, the money will come, don't worry. Today, it's not like that anymore. And most, well, I don't know most, but many of the business models are based on three things. You either charge for your service, you either send ads to the customer, or you take his data and you sell it to the highest bidder. Now, my question to you is...
The regulators in the room.
Okay, my question to you is there future for that? I mean, is there a way for these ones to abide to the regulation?
So that was the point that I wanted to, I'm also looking at the time. So what I wanted to say, and then that ties into what you were saying. First thing in the US, you definitely need to disclose, you need to have it granular. Second thing, you probably need a banner, because the California says you kind of need a banner. FTC says this banner wasn't good, this banner didn't say we are sharing IP addresses with that for advertising purposes, like you literally need to say that. So I think the FTC is looking for a banner too. The third component of it is the sale part, and that is the big difference between the US and the EU. In the EU, it's an opt-in model for anything that's not necessary. In the US, it is an opt-out model for any sharing that constitutes a sale. Not a helpful term, but a sale is basically, in European terms, a sharing that would be deemed a controller-to-controller share. If you are sharing the information through the pixel or the tracker, and the third-party provider that is the provider of the pixel, like Meta and Google and Criteo and Double whatever, they do stuff with the information that serves their own purposes, not yours, right? They are not a data processor for the purpose of this processing. That's a sale. If that's a sale, then under most of, not all of the 11, but those of the 11 where sale is for monetary or other valuable consideration, some states it's just money and then it doesn't apply, but some states it's like California, Colorado, then you need an opt-out for that click. So you can't sell it to the higher bidder unless you give an opt-out. And the third thing is, in some situations you may still need an opt-in, even in the US, which complicates it. When do you need an opt-in? In certain states, like Colorado, Virginia, and a few others, if your cookies collect sensitive information, you need an opt-in. What is the definition of sensitive information? Bigger than Article 9, and also under the new laws, like the FTC jurisdiction, BetterHelp, it doesn't even need to be, I am a person who needs therapy. It's also, I am a person who happens to be browsing a website for therapy, or I'm a person that happens to be browsing a website for medication. So very broad. You may need an opt-in for that. And then there are other laws, like the Video Privacy Protection Act, or if you do session replay, which we have lawsuits that is considered wiretapping. You may need an opt-in for that, for the VPPA. So the bottom line is, you need a notice, you need just-in-time notice, you need choice, which can be an opt-in, can be an opt-out, in short, complicated. And the sale piece is very, very, if you are considering monetizing the data, you need to get a lawyer. Why? Because, number one, you need an opt-out. Number two, it depends on how you monetize it. It could be a financial incentive. You need a whole economic value to prove that the value you're giving is equivalent to the value you're getting from the data. The regs literally have criteria that you need to do an actuarial analysis.
Or else...
Or you can't do it, or it's illegal.
Even with the most genuine, fullest consent?
So you don't. It doesn't matter. Like if you're giving a discount in connection for the data, and you can't show that the relationship between the discount and the value of the data is disproportionate, you just can't do it. It's illegal in California. You just can't do it at all because it's discriminatory, etc. So this, and the other piece is monetizing the data will put you in scope for all of the state laws. Because unlike GDPR, the US state laws, they have thresholds. You need either processing a lot of people or monetizing the data. You monetize the data, you're subject to all of the laws. So that's another reason it's the monetizing of the data is problematic.
So taking that, I think to summarize this session and give you guys a little bit of like 15 minutes for coffee and mingling, and then we can reconvene with Ian for the second part of our discussion is in practicality, and I think, Mohan, you asked that, if you are an Israeli company also having traffic on your website from the US, from the EU, or a US company also having traffic from the EU and Israel, what do you do? I think it's $1 million question because, and again, it goes to
invest in real estate and shut down your website.
In Israel, definitely. It goes back to, again, and we can talk, I think all the three of us, hours about it, what is the best practice for multi-jurisdictional compliance for privacy in general. But I think it depends on the approach of the company. If the company wants to keep it simple and to go to the highest standard, then you would probably adopt the EU standard for the entire world. It's the same as, by the way, companies are now doing in the US and adopting the highest standard from the US state laws because it's become a nightmare to comply specifically with the requirements of each state law. So that would be my recommendation to my clients. But as Odia said, we get a lot of pushback from marketing, especially in Israel, and sometimes also in the US, from companies that are still don't pass the thresholds of the new US state laws and says, okay, we have nothing in California, let's do a simple banner and let's not ask for an opt-out and just put something in our privacy policy all about cookies and go to your browser and neutralize the cookies if you want. I don't think there's one answer that fits all, but as lawyers we would always say take the safest journey, because also I think keeping track of what's changing and DPA decisions around the world and FTC decisions, especially for a startup and a small Israeli company, is a nightmare. And having to go back and amend your banner every time some decision is adopted somewhere is also a nightmare.
But it's not even the banner. It's if you collect the information unlawfully, then you're in trouble. So the thing, I would say this. First of all, maybe bribing your marketing, maybe the value of the data versus the value of the bribe maybe doesn't have to be disproportionate. So I don't know, give them all raises and get that banner, the other banner.
They're
but
going to the competitors, say, okay,
I know, I've been told that.
But they do that for everything, also for the privacy policy.
But the problem is, so the EU thing works. If you want to do that works, your marketing will kill you. The US,
work?
no, if you take the EU position, it'll be okay in the US because it's stricter.
It's
but
not
your
even okay in the EU now. You have you need to have an additional opt-in for transfer to the United States, and we're going to talk about that after the break, right?
If you take a really strict,
it's only the EU.
So if you do an opt-in, that'll be fine. Obviously, opt-in is stricter than opt-out.
Granular.
But
Granular.
yeah, granular, whatever. But then so fine. But your marketing is gonna really kill you for this, right? In the US, general broad strokes, probably better to take the stricter position among the 11 laws plus FTC, because the geolocation now with like Iowa and Oregon and whatever is a nightmare, I think. So one is you definitely need the notice. You definitely need an opt-out for sale. You definitely need to be careful with sensitive information. If you're collecting sensitive information, the FTC is coming after you, everybody's coming after you. That's really important. And the other piece is, if you have certain, like video pixels, if you have sensitive information shared through pixels, even if the FTC isn't coming after you, there are now literally hundreds of class action lawsuits in the US with respect to sharing through pixels in the absence of notice and choice. We don't have good case law because all of them are, you had nothing, you had no banner, you had no choice, That's a breach the end. So we don't know, oh, this banner wasn't good enough yet, but there's a private right of action. And so that is a problem. And by the way, the Sephora decision, they had a banner. The banner didn't opt you out of Adobe Analytics. $1.2 million fine, because it didn't opt you out of Adobe Analytics. So I think it is a good idea to take it seriously, and it is a good idea to do something, and then you negotiate with your marketing. But it also, like, the whole marketing pushback is like, hey, we can't do it. Why? Why do you need it? Oh, I don't know.
Because we get more traffic.
Because it was there. Because it was like. So
no,
you
but
need
usually they tell you we get more
yeah,
traffic
but I mean,
if it's a stupid banner.
So do you track clicks of videos? I don't know. Oh yeah, we do. Why? Don't like that has to end. But anyway, so you do need you have to be, if you need to do one thing, you have to actually go into it and make a decision mindfully. You can't just say, oh, what we get is, oh, the vendor gave us this banner. Can we use it? No. The answer is always no. But you do have to like think about it and then make your decisions. I mean, we said, you know, if you don't want to do an opt-in for your VPPA. Right? This is like, the way that I envision it in my head, and those of you that grew up in Israel, remember Eyal and the guy that like became a Neanderthal and like became, so this is like the evolution of the Schrems cases, right? From Schrems 1 to Schrems infinity, right? Like we keep every single case.
And
so
Schrems is the little red-headed guy?
It's actually a French TV show.
Yeah. It's French
animated
stuff.
show about history.
Yeah.
You remember like 30 years ago.
Once upon a time,
That's big.
yeah. So, like, where are you talking?
I'll find it.
Anyway,
The
so
internet today.
so basically, this is one of the offshoots. I think this one was your ex officio investigation, right? It's one of the offshoots of the never-ending saga of the cross-border transfers of Meta, formerly known as Prince, formerly known as Facebook, right? So cross-border transfers. Meta does the transfers out of. Meta engages with Europeans as Meta Ireland, and the cross-border transfers are person in Europe to Meta Ireland to Meta Inc. That is a cross-border. The stuff that was the easy pieces in the case was, we all know that the stuff that you're transferring is personal data. Nobody dared argue about that. This is a transfer because it is done by Meta Ireland to Meta in the US. That's a transfer. We're transferring personal data. There was other stuff that we won't get into, which is the Data Protection Authority, Data Protection Commission in Ireland has jurisdiction. And the question was, upon like a true emergency, it will go up and down. I don't know. Anyway, so the question was whether or not Meta can use the standard contractual clauses as its mechanism to facilitate the cross-border transfers. This is after, in the first iteration of this, they used Privacy Shield. Privacy Shield died in the Privacy Shield, and everybody else died in the crossfire between Max Schrems and Meta, and now it upgraded this to the standard contractual clauses. The bottom line in the case was you can't use standard contractual clauses, the old ones or the new ones, without sufficient supplemental measures when you are transferring data to the US. The supplemental measures that Meta used were not sufficient, therefore the transfer was not legal, to the tune of $1.3 million, 1.2 billion euro. So basically, the first question here for Cian is, so what is the bottom line here? What do you actually need to do, or which marketing department do you need to bribe in order to transfer personal data from Europe to the US?
Thanks, Odia, and it's great to be here at Cyber Week. I think, firstly, this question of transfers is going to remain front and centre, not only to the United States, but to other jurisdictions. For example, the Data Protection Commission of Ireland also has jurisdiction in respect to TikTok, and we have an inquiry that's very far advanced into TikTok's transfers to China. So it's going to be an ongoing issue without a shadow of a doubt. There's going to be hopefully some exciting developments in the US over the summer. But just to address your question of what you have to do to transfer personal data to the US specifically, the answer really comes from a combination of the Schrems judgments from the Court of Justice of the European Union and from, of course, our own decision recently, which is an example of those standards being applied to the facts. So really, if I was to distill the hundreds of pages between the Schrems judgment and our own decision, which is now published on our website, I'd say that there are three key principles to take from the Schrems judgment. The first being that if you're relying on Article 46 of the GDPR, so if there's not an adequacy decision, like there is an adequacy decision in respect of Israel, there's not an adequacy decision in respect of the United States. So if you're relying on Article 46 to do transfers where there's no adequacy decision, what the Schrems litigation set out is that your safeguarding measures that Odia already mentioned must provide a standard of protection that is essentially equivalent to that in the European Union. And secondly, the second principle from the Schrems judgment as well from the Court of Justice of the European Union is that FCCs are a valid way to do that. However, if the FCCs, and this is the third principle, if the FCCs can't be complied with, or if essential equivalence cannot be achieved through other means, then all supervisory authorities, such as in this case the DPC, the Data Protection Commission of Ireland, are obliged to suspend the transfers. So what you're looking at there is whether, having regard to all of the various different safeguarding measures that you can implement, does it provide an essentially equivalent standard as is provided in the European Union? So that's what we are applying when we considered it in our Meta decision. The clear judgment from the Court of Justice, of course, doesn't apply the facts to the law. It just sets out what the law is. It still falls on the supervisory authorities, such as the DPC, to apply that law. So really, our decision had two key principles then in applying that law. The first being, we found that the SCCs, the standard contractual clauses, are not binding on the US government. So that was really crucial to our finding, because Section 702 of the Foreign Intelligence Surveillance Act allows for that surveillance from US surveillance entities, and Section 702 does not have limitations on the powers that the US entities can use, and it does not have safeguards so that those interferences with the fundamental rights set out in the Charter of Fundamental Rights of the European Union are limited to what is necessary. So they're very broad powers without sufficient safeguards for a European standard. And then, so having regard to those standard contractual clauses and the manner in which US surveillance agencies could compel access from Meta Inc. rather than Meta Ireland, we then had to consider the remainder of the safeguarding measures, and we found that the remainder of the safeguarding measures implemented by Meta, of which there were plenty, but even having regard to all of those measures, they were not sufficient to achieve that standard of essential equivalence, because they didn't address that fact that the surveillance authorities under Section 702 of FISA could compel that access to Europeans' data without any limitations on the scope. So really, what is needed to transfer personal data to the United States? You need a data transfers assessment that demonstrates that that essential equivalence is in place. And really, on the facts of the Meta case, where Meta is an electronic services communications provider under Section 702, and therefore Section 702 applies, we found that that standard of essential equivalence had not been met. And as a result, which we can get into a bit later, we ordered a suspension on transfers, and following the consulting with the other data protection authorities around Europe, we also ordered a deletion and a €1.2 billion fine.
So this is the concept that I call hashtag the NSA ate my cookies. So because the NSA eats your cookies, then as long as this is accessible to the NSA to eat the cookies, it doesn't matter that you're like, please don't, or I recognize that the plate is whatever perforated, right? So what I have a sort of unexpected question that I don't know, you may or may not be able to answer, but would this whole problem, there are different issues with it, but would this whole thing be avoided if like Meta canceled Meta Ireland and just did everything directly from the US?
It wouldn't, no. Looking at the territorial scope of the GDPR, because data is still being transferred outside of the European Union to a third country, that standard of essential equivalence would still
But
apply.
would there be a transfer? Wouldn't it all be direct collection if they did everything from the U.S.?
Yeah, I think within the definition of transfer, it still constitutes a transfer of data outside of the European Union, regardless of whether the data is being stored on a European server before it's transferred to an American server.
So the supplemental measures thing. So here's what Meta did that was not enough. First of all, the fact that Meta said that in its experience, the U.S. government requests do not amount to anything that could be considered bulk, that's not good, right? So this is like, oh, I consider this cookie not fattening, not helpful. If Meta says, all requests are subject to the terms of an independent court-approved certification with minimization, not helpful. Meta had transparency requires. We're going to tell the people. We have teams to review government requests. We require notification from the U.S. entities where we receive a request. We are requesting reports. We have quality assurance arrangement. We have logging. We have configuration management. We have change management. We have vulnerability management. We have regular auditing. We have a comprehensive information security program. We have a shared infrastructure between Meta and Meta Ireland. I don't know how that one helps, by the way. I feel like it's a problem. Asset management controls, cryptographic protections. We have, we challenge things that we believe are unlawful or overly broad, right? So like all of that, they did all of that, and they said, like, we did all of that. We have like 50 measures. And basically the answer was, I don't think it was your answer, but I've heard Max Strem say this as the answer. It's like, okay guys, you're compliant with Article 32, now what? So if all of that isn't enough, right? What type of supplemental measures actually are enough in order to enable a transfer? Specifically, let's start with the U.S. I'm like very curious to see the TikTok decision. But what would that be? Instead of the NSA, it's like Supreme Leader ate my cookies? I don't know. But I'm waiting for that one. But for the U.S., right, what does work then?
Yeah, so the decision looked at this in some detail and looked at the safeguarding measures that were implemented, including encryption in transit. So even if we take the encryption in transit as being impenetrable, what the issue was that under Section 702 of FISA, the US surveillance authorities could lawfully compel access to that data once it landed in the United States and once Meta US or Meta Inc. Had control of that data. So we looked at all of the safeguarding measures that Meta did implement, and none of them addressed that particular risk, that Section 702 the US authorities can gain access to the data, and tied into that is of course how Section 702 does not have limitations on its scope in respect of European data. It doesn't apply to US citizens' data, but doesn't have limitations on the scope of how Section 702 applies. It doesn't have safeguards in place to make sure that the sort of surveillance that the US authorities are seeking to achieve is limited to what's necessary and is actually targeted at what's necessary, and goes beyond what could be considered just bulk surveillance. So really there were no safeguarding measures that Meta could identify, and it's up to each controller to themselves identify the relevant safeguarding measures. And at present, certainly if Section 702 applies to you by virtue of being an electronic communication service provider, it's certainly very difficult to, in the current climate, envisage any measures that could help you achieve that standard of essential equivalence.
So that's a really big statement, right? So here's the situation. First of all, what I'm going to translate what you just said to explain it to me like I'm 5 years old, and then you can correct me. So the first thing, what doesn't matter? It doesn't matter what the NSA says that it is, doing with the information or wants to do with the information. There was a white paper by the Department of Justice that basically said, we don't care about like 97% of the stuff. We never look at it. We don't care about it. We're not. I had a client that sent me, and I told him about it because I thought it would be a good idea to incorporate it in the DPIA, specifically as with respect to their specific data, which was very not risky, etc. But they sent it to me. They're like, oh, we're not going to do a DPIA. We're just going to give this with this white paper. I'm like, that's not helpful because, as you just heard, right, from the regulators, the fact that the NSA says they want or doesn't want, the fact that they could, meaning the law doesn't prohibit them from doing it, then that's enough. That's enough of a problem for the problem in the U.S. law. The second answer is, unless you find a way to literally, from a technical perspective, well, either you're not an electronic services provider, right? That which is, you probably may not be, even though the definition of FISA is so broad that it's a problem, and it has been interpreted as if you give your employees a work email, then you fall in scope, right? Like, that's depressing. But let's say in those situations, I feel like, you know, you may have a lower risk of enforcement. But but that doesn't matter, because as soon as you use Google or Amazon or Microsoft or Facebook or whatever for your storage, which, you know, unless you're like, you know, my father-in-law, who does not believe in the cloud and stores everything in a hard drive, like stacks of hard drives on his desk, then you are using an electronic communication service provider, even if you theoretically aren't. So that doesn't matter. So once you fall in scope, unless you find a way to technically, literally lock out the NSA, such that they can't, even if they ask you, and so this is why we don't tell my 8-year-old secrets, right? Because once we tell her, they are, you know, if we don't tell her, then she can't tell us, right? So if you're able to lock out the NSA from a technical perspective, that I think would be a sufficient supplemental measure. The problem is that
would that be the only one? That's the question. Is there anything else other barring, like, making it technically?
AWS or GCP as a provider, isn't that sufficient?
What is it?
If you use, you know, like a cloud platform like AWS or GCP as a platform to transfer data from the to the US, I believe that the NSA can.
Yeah, that's it. AWS is an electronic communication service provider.
As a company.
So
when you are not Meta, okay?
So basically, the thing that allegedly works, I don't think it's been tested because it hasn't been. I don't think it's been enforced. But if you find a way, there have been solutions in the past. I think Microsoft has one. Maybe they're back to having one. I think some of the providers are looking at it. They had these, like in Germany, they had them. They had these like lockers, like these trustee lockers or something, where there was an arrangement that literally there was some sort of European intermediary that made it such that Amazon couldn't see the data that you are storing in Amazon. So they couldn't tell the government even if they wanted to. They didn't have the way. The other sort of things are like, you know, bring your own key and things like that. But then you run into issues. It's like, what is the bring your own key? It's the bring your own key for the stored thing. But then you have like encryption and use, and then like the NSA pounces at the moment of decryption like a tiger. So then, but that's, I mean, so barring a technical lockout, is there anything else that you can do?
Well, the way the conversation is going now is in terms of legal measures, because even if you have technical measures that, you know, are impenetrable, once that data reaches the US entity, they can then be compelled to provide access to it. So we are moving towards legal measures.
If they can, right? If it's encrypted such that they don't have access to the decryption key, then they can't, even if they wanted to, right?
Once they can't compel the
right.
encryption key from another jurisdiction. So the legal measures that we're moving towards, and we've seen President Biden has signed an executive order that will limit this. Say again? Yeah, that would limit this surveillance to standards of necessity and proportionality. We're moving towards a data protection review court in the United States. So the United States has made significant changes, which are really legal measures rather than technical measures. And what we're seeing now is that the European Commission is considering those changes, and we'll have likely a decision on whether the US will receive adequacy from the European Commission this summer. As it happens, the Meta decision has a deadline of October for Meta to comply with the suspension and deletion, but that order could become superseded by any adequacy decision that's made by the European Commission, which of course isn't a matter for the DPC or any of the European Data Protection Board supervisory authorities to decide upon. So ultimately, it's a question of legal measures now and whether that standard of adequacy is satisfied from the European Commission's perspective.
So basically, but what he's saying nicely is that there is no solution. If you are not able to make it such that the U.S. entity wouldn't be able to provide the information if compelled, right? It's just there's not. It's not like, you know, I don't know. Think about, like, I don't know, torturing prisoners, right? Like if you have the information, you will break at some point, right? And even if you're really dedicated. But if you don't have the information, then you don't have anything to give. So if there is, unless you are able to make it such that the U.S. entity will not be able to provide the information ever, then you have a legal problem. And the solution is basically a change in the law, right? And what Cian was talking about is the EU-US data protection framework, which we're going to talk about in a second. I don't know if I want to ask you this because you already answered the question, but I think maybe I'll ask you guys this. Okay, so what are you going to then do, right? There is pretty much very few legal ways to not have a data transfer problem. And there just isn't, because unless you are able to do that, the sort of not. So the law school answer here and the regulator answer here on is there a legal way to do it? Almost no. And the only legal way is the law hopefully will change. We're going to talk about how. But like in real life now, okay, now what? So I think that, you know, notwithstanding the fact that this is not a risk-free issue and there is a formally a liability, I think it's like, you know, you shall not, you know, take the name of risk base in vain, right? But I think there is no other way to do that. If, I mean, you know, you could also, again, like get a plot of farming in the north and, like, you know, go like make cucumbers or something. But if you need to transfer data, right, there you need to, what I advise clients, right, is knowing that this is still a legal violation, you want to mitigate your potential for getting enforced against and the severity of that enforcement. And how do you do that? I think the first thing that you need to do, which you should have been doing arguably anyway, is do the GDPR stuff that you should have been doing anyway. Do you really need, first of all, and this, you know, may or may not apply to Meta, and you can like smile or not smile, right? So, like, should you have been collecting this information in the first place, right? Should you have been transferring the information in the first place? Should you have been doing all of this stuff in the first place? But that's an actual thing. Like, why are you doing that, right? I mean, and you asked, it's the same we said about the cookies. Do you actually need this? Do you need to do the transfers? Can you do fewer transfers? Can you do some things in the EU, right? Can you, this is like sad, because I think, I personally, you know, my personal opinions are that there is a fair, and this is above everybody's pay grade, but I think there's a fair bit of like political issues here in this whole thing, right? But because arguably the NSA may or may not be worse than other counterparts in the world. But if you are able to use European providers, great. If you're able to pseudonymize the information in the EU, great. That's actually an exception in the EDPD guidelines. If you're able to pseudonymize the data, and God forbid the US provider has access to the pseudonymized data, but AWS does not, then it doesn't fall under the exception. But if AWS has pseudonymized data that a non-electronic communication service provider controls, okay, it's not an exception, but the AWS can get it. It's got pseudonymized data, right? So, okay, pseudonymized data is personal data, but the potential harm is X, right? Can you bring your own key such that you put your key inside your Amazon, and it's not an Amazon, you know, SRL key that Amazon Inc. can get at. It's a key that Amazon cannot get at. Then so like do what you can in order to like reduce the surface area and the nature of the data transferred, right? Like if you have special category data, health information, sensitive information, like really do your utmost to not transfer it. Like that's obvious because there's already case law on it and DPI and transfer impact assessments that said that if you like, you know, like the experiments, you have a micro droplet of red in the water is no longer clear. Like you have sensitive information, you're screwed. So try to not do that. If you have non-sensitive information, try to reduce your risk as much as possible. That will still not be legal. But so is parking in red white for like 2 minutes when you get milk, right? But like when do you get caught? Very few times. Is that a fair statement?
Depending if Murphy is there.
Yeah, exactly. I mean, you know.
And of course, all of this is relevant to Israeli companies as well for two reasons. One is
You want to show the proof?
Hmm?
Do you want to show the proof first?
no, I think it fits
I
right
think-
up.
Yeah.
So two things. One is we have regulations limiting export of person data, which basically rely on a European transfer mechanism. So one of the ways you can export data from Israel is under the same terms as EU data is exported from the EU, I imagine. So if there is some solution, sometimes we can rely on that. Other than that, in Israel, you either need consent, and we talked a lot about what Israeli consent means, so not much. But I think in the context of Meta, that is one of the, consent is one of the derogations, but basically somehow not applicable here.
Yeah, is teeing up our question here. What did you guys do to the derogations?
Yeah,
Why
so
did you kill them?
Maybe Odia for the Israeli
Yeah,
audience,
for-
give a minute
So,
about what
yeah, right,
derogations
5
are.
seconds on the derogations. So in order to do a cross-border transfer, right, you either need adequacy, okay, we don't have it, maybe we will, but we don't. Or you need the SEC's plus supplemental measures, empty set of supplemental measures, that's also a problem. Or you can have derogations. There are certain situations where for very specific and stated by the EDPD guidance, not continuous, not regular transfers, there are certain circumstances where you could do the transfer even though the destination is not adequate. The Meta brought a few of these up. One of them is public interest. No idea how that applies. I'm curious, but it doesn't matter because public interest does not apply to most of everybody. Contract, the transfer is necessary for the performance of the contract, or consent. The individual gave consent for the transfer. And the typical things are you buy a hotel room for the night from Expedia and you are, whatever it is, somehow there is a transfer because you do that through a European, there is a transfer somehow. It's not a direct collection, but there is a transfer, right? So in that situation, okay, you give your employer your credit card number such that you can get the hotel, right? So the information gets transferred, but it is necessary for your transfer. It is a one-time thing, etc. Somehow, something bad happened to the derogations in this case, specifically, I guess, for the U.S. So what happened? Why?
So I suppose that's a very good intro. It really captures the derogations because so far we've been talking about Article 46 and that standard of essential equivalence, whereas the derogations can still be relied upon even if a third country receiving the data isn't essentially equivalent, or if the transfer isn't essentially equivalent. But Odia, you asked whether why we killed the derogations, and there's a debate as to whether the derogations died in the Schrems II judgment or whether they died when we were applying the Schrems II judgment. And I would definitely say it's the case of the former, because the Schrems II judgment set out how, in respect of the interference with fundamental rights in respect of the surveillance, the US law did not respect the essence of the fundamental right. So it wasn't just a simple interference, but the Court of Justice European Union found that the essence of the fundamental right was not respected. And which fundamental right are we talking about? You might be thinking it's privacy or data protection in Article 7 and 8 of the Charter, but in fact, in this case, it was Article 47 of the chapter, which provides for the right to effective judicial remedy. So it wasn't even an application of the right to privacy that the court found that the right, the essence of the fundamental right wasn't being respected. It was the right to an effective judicial remedy. And essentially, in circumstances where the data was being transferred, what the court found was very significant was that data subjects had no remedy to access their data that was being accessed by US surveillance entities, no rights to delete it, no rights to rectify it if it was incorrect. And in those circumstances, the essence of the fundamental right was being infringed. And essentially, derogations are, by their very natures, they limit fundamental rights. That's what they seek to do. So to rely on derogations, the derogation has to be provided for law, which it clearly is in this case because of the text of the GDPR. But it has to also respect the essence of the fundamental right. And only if it respects the essence of the fundamental right do you get to the stage where you consider proportionality. But because there was absolutely no effective judicial remedy available to EU data subjects, we didn't even get to the proportionality stage of the test. We didn't even consider whether the US access was proportionate or not, and we didn't have to, and we couldn't really, because at second limb of the test, the effectiveness and the essence of the right had already been failed.
I have a rude question then. Suppose I'm French, and Sûreté, which is like, I guess, NSA, has data on me, a French citizen. Do I have a right to know what they know about me? Can I rectify wrong information? Can I say, oh, you suspect me, but just delete the data because GDPR and now you don't know anything about me again? Probably not, right?
Yeah, no, you're right. You can't, because GDPR doesn't apply to national security.
You can't kick France out of the Union because Belgium will, support it.
So basically, the situation is, in a way, the US is held, or non-EU member states are held to a higher standard than EU member states hold themselves.
And on top of that, what I would say, when Brexit happened, there was a very real debate as to whether the UK would have adequacy after leaving the European Union, even if there are no changes to data protection law in the UK, just by virtue of the national surveillance exception no longer applying to them, and therefore whatever MI6 is doing, all of a sudden is a problem from an EU perspective. So you're right, there's an exception that European Union data protection law does not apply but to internal security matters, but it does apply to transfers to third countries.
And somehow they completely fudged over the GCHQ situation in the adequacy decision. It was like blah 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 surveillance, but look, GDPR is the same. So if that were, and in the US, it doesn't even, there's no even discussion of the US law. But basically the bottom line is, the answer here is, you cannot use necessity for contract-based derogation for the US for this decision. What about consent?
So consent is a little bit different, essentially. And the first point, we discussed consent earlier in the first half of the session, but for consent to be valid in respect of transfers under the GDPR, it has to be explicit and it has to be clear. So it's a very, very high standard indeed. And what's also clear is that one single consent is not sufficient for ongoing transfers, and it's not sufficient for sets of transfers. So you essentially need a separate consent for each transfer when relying on that derogation under the GDPR. So what that leads to is a situation, this was acknowledged by the Court of Justice, European Union, is that in light of how, for example, when relying on consent, you have to bring the risks of the transfer to the attention of the data subject, and in light of the onerous nature of consent under the GDPR, that if you do obtain valid consent under the GDPR, that's capable of removing that infringement with the essence of the right, and therefore transfers could still be based on the consent derogation. But as I mentioned, that consent has to be obtained each time you're making a transfer, so it's not appropriate for systemic bulk transfers. It's not appropriate for the type of transfers that Meta was doing in storing its data.
And so this is a little bit of a silver lining here. Yeah. So this is a little bit of a silver lining. So the consent thing was not effective for Meta because they had, 15,000 transfers going on. But for you, if you have a transfer which is less complicated, and you are able to properly articulate it such that the person understands what is actually going on and give Article 7 appropriate consent, then you can use consent as a transfer mechanism even for the US. It needs to be, it's not bulk, it's not repetitive, it's within the parameters of 49(1)A, and you need to do the transparency standard, which is very high. So it's going to be very difficult for you to do that for maybe Metapixel or Google Analytics or whatever, things that are complicated transfers. But for those transfers that are, necessary for stuff, theoretically, you may be able to save some of those transfers through that. Did that answer the question, or did you just lower your hand?
I wanted to ask if the consent can be obtained post-fact.
It can't.
No.
Yeah.
No.
No, it's not consent.
No, not even in Israel.
I asked if it could be stupid question, but that's what I asked.
Do you want to speak about adequacy in Israel, or we have like how much time? Do we have 5 minutes?
Yeah. Let's. But we want to show them something first.
Yeah. Okay. So we'll speak just a little about adequacy, the adequacy decision that we're waiting for in Israel.
I have to say I'm just loving the questions and comments, watching them coming in. Someone has asked, how did Israel get adequacy in the first place? Well, yeah, also a good question.
Okay, so that was from a webinar in 2020, maybe 2021, and someone asked, how did Israel get adequacy in the first place? We got adequacy in 2011.
And that was Cian's boss, by the way.
Yeah, okay.
Who's not familiar? People that are not familiar.
So, and we know we're now being reviewed together with the US and plenty of other jurisdictions. And Israel did a few things, like declared independence of the regulator by a government decision, and we have regulations applying all sorts of requirements that the Commission asks for on data that comes from the EEA. But I think the overall review, the scope of the review, taking Schrems 2 and the GDPR into account, has widened. So we're now talking about fundamental rights that might have not received such a focus before. What sort of things would the EU look at from the perspective of Israeli law? What are our chances, basically?
Yeah, sure. So I suppose when deciding on adequacy, it's a matter for the European Commission. So it's not a matter for data protection authorities, which may show why Helen was questionable. It's not for us to decide. And what you'll see, even from the history of the Court of Justice European Union, is that the Court of Justice has a history of striking down adequacy decisions that the European Commission has made. So it's a question for the European Commission. Schrems 1, Schrems 2, the Court of Justice, when reviewing the adequacy decisions, did strike them down. One point to note is from the Schrems judgments, Schrems judgments set out that those adequacy decisions should reason in detail why a country is adequate. And what we've seen since those judgments is the European Commission adequacy decisions, which are all available online, have got much lengthier and much more detailed. So they're following the approach set out by the Court of Justice. So if you look at the Japanese or South Korean adequacy decisions, they're much more detailed than some of the earlier ones. So it's clear the European Commission is setting a high standard of review, and they look at a wide range of issues when considering adequacy. So you don't have to have an identical level of protection, but as I mentioned earlier, you do have to have that essential equivalence. So, for example, like we discussed already, legislation permitting access for public authorities is one issue, data protection rules, questions of onward transfers from the third country to another fourth country, effective and enforceable rights are all matters. But if we do look at some of the existing adequacy decisions, we'll see that many matters are tolerable to the European Commission, where perhaps there's not the same standard of data protection rights, but there is tolerable differences. So for example, in the case of South Korea don't have the same standards. They don't require data protection impact assessments or records of processing activities like the GDPR does, but that's not something that stood in the way of adequacy. In the case of Switzerland don't require the appointment of data protection officers the same way that the EU does, and again, that was something that was tolerable and they still got adequacy. In New Zealand, for example, the threshold for refusing a subject access request is much lower, and again, that didn't stand in the way of European adequacy for New Zealand. Again, another one for Switzerland is that you have to opt out of direct marketing rather than an opt-in in the case of the EU, and even that didn't stand in the way of adequacy. But I think some issues that are likely to be less tolerable for the European Commission are really like fundamental rule of law type issues. Questions of onward transfers are definitely less likely to be tolerable as well, because the entire protection would be undermined if you could just transfer to another country at that point. So It'll be interesting to see where the European Commission might refuse adequacy in the future, or indeed reverse adequacy. But at the moment, I'm very conscious that all of the adequacy decisions we can talk about found adequacy. They didn't find a lack of adequacy. So we're sort of trying to look into the mind of the European Commission and working out what exactly is going to hit that standard where it's not a tolerable difference, and where in the European Commission's view there isn't a standard of essential equivalence.
I think we, as local lawyers, also identified two areas where we are concerned that might be some kind of hindrance to the renewal of the adequacy. One is definitely the cross-border aspect, because as we said before, under Israeli law, basically you can do anything if consent is provided. Also, one of the options of cross-border is a data subject consent. Again, provided it's informed and the data subject knows what they're consenting to. So you've seen many privacy policies in Israel where data is processed, for example, in the US, that it is stated the data is processed in the US, is held on cloud services in the US, and the data subject is consenting to that through the implied consent that is possible and legal in Israel. And this is, I think, this could be, I hope not, but it could be an issue where data is brought in from the EU or the EA into Israel, receives all the equivalent safeguards, and then is exported to the US. And as we know, if we're talking direct link to the Meta decision, without anything but the data subject consent. And that's not the EU consent even under the derogation. So that's one area where it could be problematic. In addition, the list of for example, UK has been determined an adequate country under Israeli law. If the UK, it's just an example, loses adequacy, then it is still adequate under Israeli law for other parameters. The other area would be the laws enabling government and authorities access to data, which Eyal wanted to put a few words on.
So we've seen the sensitivity around, let's say, NSA access. Of course, we have, like European countries, we have national security laws, and we have a security agency, our Shin Bet, and they have rights of access. I'm sure the Commission will look with interest at what Israel not only says on the laws, but what it does, because that, you might have a law that says, the Secret Service won't access personal data indiscriminately, yet they do.
It's the reverse problem with the US, right?
Yes,
we
so
say that we do, but we don't, but it doesn't matter.
We have this case of the police using all sorts of intrusion tools, and that's now a subject of a parliamentary committee hearing. The thing is, I think, in Israel's defense, I will say, well, there are a lot of things going. I don't know what's going to happen. The right of the Supreme Court to review government decisions is about to be narrowed. It has been threatened for many years and might happen now. And many people point to what Israel did during COVID as an example of disproportionate, indiscriminate access. Well, basically, the Secret Service was tasked with finding COVID tracing and people who breached, basically left their homes.
Quarantine.
Now, the Secret Service, if you remember, didn't want this. They objected. They said, we're not here to mass surveil.
This takes away CPU from our invasion of phones when we actually need it.
Yes.
Yeah.
We don't do this. We don't act against innocent civilians. The government insisted. So that's a bad point. But remember the reaction. The reaction was, one of the things is, these guys intervened and the Supreme Court helped them, and they published reviews, like, what was it, monthly, bi-monthly reviews of what the Secret Service was doing, and they got rid of it as soon as they could. So there is this element of basic respect to privacy that even the our equivalent of the NSA adheres to. They keep saying, we don't want to do this. This is not within our remit. Don't change what we do. And the other thing is, I think, compared to the US, there is universal standing in Israel. So I strongly doubt if an EU data subject is asking to see what the Israeli security services have on him or her that they will get access. I certainly won't. But if there is, if you want judicial review, at least, this is, I think, unlike what the situation was in the US, no one is going to tell you, or you're an EU data subject, you don't have standing because you're not a citizen of Israel, which is something that is going on in the US. You have constitutional protections that only apply to US citizens, or at least had them, and EU data subjects didn't have these rights. If you go to the Supreme Court of Israel and complain, even if you're not a citizen, you have standing.
99% of the time you won't even know that you need to complain.
That
makes it moot,
I'm,
but yeah.
I'm not saying, you know, it's a walk in the park. There are certainly issues. But there are also important differences between what's going on in the US and how Israel approaches the subject. But I guess we'll wait and see. It's one of those things that are about to happen for quite some time, right? The adequacy decisions, and also Amendment 14 and 15. We moved from we're working on it to it's done to okay, we'll try to legislate. Oh, the Parliament dispersed. Oh, we'll restart, and now we're in very soon for Amendment 15. Okay, so we're restarting Amendment 14, and very soon Amendment 15, and these are really the subject matter GDPR type things, which is also interesting. How the Commission would review a country that gives certain rights to data coming from the EA, but still basically lacks the whole modern framework of data protection, like legal basis. Everything here is consent.
But also to add, right, one of the issues, and this is flagged by the DPC or the EPD or both in the decision, is the issues with the independence of this new court that was established as part of the DPF called the Data Protection Rights Court. And everybody, if you look at Max Schrems, he will say up and down, this is not an independent court, this is not an independent court. So the question is now, with the questions of the, with the judicial reform, affecting the independence of the court, like you have the same arguments potentially with respect to the Israeli judicial system.
So
you
it
have
needs to be
recourse,
seen what happens
right.
with this part of the reform.
I mean, the argument sort of stands, right? The fact that, and also, by the way, the independence, right? The government decision on independence, right? That's the same arguments with respect to the DPF, right? But those are the same arguments against the data protection framework that are being raised. So, and most importantly, don't get a whistleblower, because without Snowden, we would not be.
We won't be sitting here.
So
I think we're past our time. So maybe Cian, anything you want to wrap up, or any final statement from you?
I gave a shout out to our TikTok decision earlier, which will be exciting once we can speak about it. It's at a confidential stage.
Will it be published on TikTok?
It will be published eventually. We haven't yet provided a draft decision to the other supervisory authorities within Europe. We're waiting for final submissions from TikTok. At that point, we'll prepare our draft decision, which is essentially our own final decision, subject to what the other supervisory authorities have their right to make comments or to object, which then...
And that's not public, right? The draft decision is not public.
It's not public, no. It's just shared with the supervisory authorities.
But people are like, for the draft decision for the Meta one, there were rumors about like the fine was lower and...
Yeah, I mean, it's being shared with... well, if you include all the supervisory authorities, not just the member states, you're looking at 48 different supervisory authorities. It only takes one if there are leaks.
One employee from
one
authority.
within, so it's a number that's much bigger than 47 even. But we share that with the other supervisory authorities, and then we will have our final decision, which we hope will be soon. So that's going to be naturally a whole new series of transfers issues.
Do you think that's this year, that's in 2023?
I would say it's definitely likely to go to Article 60 this year. I'd say at that point it depends whether we get objections or comments, and how the Article 60 process, where we're consulting with the other supervisory authorities, is unpredictable, to say the least, just because we have our final decision, which we consider to be our views, and then if we get comments or objections, we have to try to reach consensus and try to engage and try to make changes if they're applicable. So it's hard to predict. At the moment, on average, if we do get objections, we're looking at really a significant period of time in the Article 60 mechanism.
When was the draft Meta decision?
I think it took about 9 months to get through. It was last summer, actually. So yeah, you're looking at, if it goes to 65, which means that the objections haven't been resolved and we need to go to dispute resolution, the dispute resolution which happened in Meta, that added close to a year. So it really depends on whether we get objections or not. There's a lot more clarity in the law now following Schrems 2, and there's also more clarity of what the EDPB expects from the process in the Meta case. So of course the DPC has to have regard to that when making its draft decision. So it'll be a very significant one. We can't yet speak about it, but maybe this time next year in Cyber Week we'll be able to sit down together and discuss it.
Well,
So
I'm
looks-
sure TikTok to show.
Yeah, it looks like the DPC is going to have an answer to this. Meta responded to the decision. Basically, one of the things they said, no country has done more than the US to align with European rules via their latest reforms, while transfers continue largely unchallenged to countries such as China. So it looks like that's going to change as well.
I hope so, yeah. We started this inquiry in 2021, and it was very detailed, so there's certainly been a lot of work going on in the meantime. I know that's not public, so it might seem like there's nothing being done about China, but as you can imagine, it takes a lot of investigation to bring a draft decision as far as it needs to go. So the work's going on in the background, but people just don't see
And
it
this
yet.
is an ex officio investigation?
Yeah,
Or this is
yeah, open volition, no complaint. There actually isn't a specific complainant like there was with Mr. Schrems in the Meta
Yeah,
case.
he's too busy with the NSA for China. He's fine.
He actually talked about it in a meeting with the Federal Strategy. He said like the amount of data transferred to Facebook is nothing compared to the amount of data compared to TikTok, and that's why he did complain about it.
Because TikTok is less?
Yeah, he said the amount of data transferred
And
to the
TikTok
US
is kids, so.
Yeah.
I think he doesn't like Facebook.
Yeah.
especially.
I think he just needs to see it through. In November, he said he is emotionally tired from the transfers discussion, but he can't not see it through anymore. So,
Oh.
yeah.
I have a question about the practical aspects of associating identity with the consent and recording the consent. Because you said that the consent is a practical solution for data transfer, but the record of the consent and the association of identity and the consent is different in different places. So how would that work practically if you want to rely on the fact that the
Well, for EU, we mentioned before, you need to demonstrate that consent was given. Because it needs to be separate, freely given, all of that, then you are supposed to have probably a specific record noting the act of opting in, the affirmative act of opting into the specific consent on which you're relying. If you can't do that,
who was the entity that opted in? So
The
you have
person,
user and
the
subscriber in Europe.
Yeah.
You don't have this in United States.
But
And in some places
the consent
you
is
do-
an EU consent. It's the derogation is EU law enabling you to transfer EU data to the US. That's the consent we
That's it.
discussed here.
Yeah.
Derogation. So the European person, or IP 1234556, says, I agree that my data goes to the US for the purpose of storage and for the whatever, to store it and to conduct analytics on it, and I don't know, you
And
have.
that's enough for Europe.
Yes, that's
But
the
is
only-
it enough for Israel? I'm not
well,
sure.
Israel
It's even simpler.
is,
Sure.
theoretically speaking, we don't know what will happen, but theoretically speaking, if your terms of use are clear that you're transferring data to the United States you know, very often you will see, by using this website, you agree to everything we say, and we say we transfer to the US, and if you don't like it, don't use the website, even if your life depends on it, sorry. Then basically, you know,
that's consent.
That's consent under Israeli law. The authority is saying all sorts of things, especially about employees, and it's, it's good, but the bottom line is, as long as we just have consent.
I'm talking about me putting more details on the website, not
then you
me
need
putting
to
my
get
details.
my consent.
Then you need to get the other
consent.
person's consent, otherwise you can't do it.
But the bottom line is, if you have one consent, one standard of consent, applied, conformed, specific, whatever you want, in Israel everything is just the consent. So if you have that, you cannot separate. We have to have this data, or your hotel room will not wait for you in New York when you land after 12 hours of flight. Sorry, okay?
But you will have
no
protected-
choice.
But you will have protected the fundamental rights of Europeans.
Right.
So it's a small price to pay.
And you cannot separate and you also consent that we transfer marketing data, and the hotel will use it for marketing. It's the same one, right, in Israel. So theoretically speaking, you need the one consent. I know the authorities advocating separating that. I think, I recommend it. But there is no way in Israel to say, this consent you must give me, or if you don't, you can't get the service. This consent is your choice. Maybe marketing is there.
But that's
'cause
more
there's always
spam law.
opt-out.
It's more spam law
It's more
than
spam law, and you
privacy.
always have opt-out from direct marketing. Analytics, can you say, if you don't agree to analytics, you cannot use this website, and we are sorry your million shekels in the bank are gone, because, if you want the money, you need to consent to analytics. Of course, in the EU, that won't work, right?
In Israel, even for the regional councils and city.
In Israel, the website of the
conditional,
Protection of
probably.
Privacy Protection Authority has Google Analytics, no opt-out. I'll tell you one more thing that they have. If you want to report a data breach, you go through CAPTCHA. And you don't go through CAPTCHA Pro, we are processors. You go through CAPTCHA Free, we use your data. And if you don't like that, then
Yes,
maybe
unsupported
send an owl to the agency.
By the way, you can
Basically,
send
like,
them
it's
the report by
international
email.
collaboration, right? In consideration for your Israeli privacy claim, we are sharing information with the U.S. industry. I think it's just, global.
Yeah,
info,
so- So we'll see. I mean, the cookie cases, with the 40-odd defendants, I lost count. We'll see what the court says.
If they reach a court decision, they'll probably end
I
up
don't.
settlement.
I don't know. We'll see.
Can I ask a question which related to the previous sessions? That's okay. It's about the transparency requirement in EU in relation to cookies. How transparent does it need to be in terms of what cookies you're actually using on the website? So I did see different approaches in relation to, for example, a complete list of cookies, what they do, what they share, etc. This is the most detailed approach, but there is also other approaches. What is the best approach, or what is the compliant approach?
Yeah, I mean, I don't know. I think the most compliant approach would be to do that, right? To like there was a decision, I can't remember where, but there was some guidance, definitely guidance. But if you look in the Belgian Data Protection Authority's page, on their cookie page, right, the APD, GBA, they have a chart, and the chart has name of cookie, data collected, purpose, and retention term. And this is pursuant to some guidance. I don't know, maybe Keneal, I don't know. And that's basically what they said. And I think that I can't really see from a transparency perspective with the requirement, especially the Meta decision too, but also the Spotify decision, and also there were a couple of others that talked about granular disclosure. right? They all say you have to tie the data to the purpose, to the sharing, to the retention. And as I mentioned, in California, there are at least 2 places where they also say that. We haven't seen enforcement, we haven't seen anything. I don't see how, if you're just implementing the same transparency standard, why wouldn't that be the case, right? We need to do it. Let's say, who cares it's a cookie? I collect your name in order to put you in my list, in order to whatever, and I retain that for 2 years. Like, you have to say that. Why would you not need to say that for the cookie? It's literally the same thing, right? We collect your identifiers, parentheses, name and last name and this, right? So we already have to do that. I don't see why you don't. And so we'll see and we already have enforcement. If you look at MOE in Sweden or Norway, I think it's Sweden, Spotify, TikTok, which is ICO, 13 million pounds because they had a privacy disclosure that wasn't granular. So why wouldn't that apply to cookies? So that's what I think. I think it's the same. Now, I was asked, do we have to put it in the privacy notice where it's difficult to update all the time because our cookies change all the time? I'm like, why do your cookies change all the time? That's a different question. But they keep changing and it's hard to update. Can we just do it in our OneTrust banner or whatever, right? Like that, I don't think there is a reason not to do it. If there is one place that has the description and it's currently updated and there is an easy way to get to it, why wouldn't you do it? But should there be one place where that is? I think there should be. Has it been clearly enforced yet? No. Do the different European data protection authorities, can they even decide on their one standard for cookies? Also no. If you read the EDPB cookie task force thing, so if you read between the lines, the one thing that you can say is, you haven't been able to figure out your cookie deployment thing? We haven't either. And here is what we can decide, right? So, but I think the writing is on the wall. So then the question is, when is it?
And it goes, I think, to the general principle of transparency, where if you're telling people you need to choose, they have to understand what they're choosing. So if you tell them in general we use cookies, it's probably not enough.
How surprising would it be to you if I say the Belgian Data Protection Authority, with a nice page about cookies, doesn't comply with its own.
No, they have it. It's in there. It's not in there. No, it's not. I don't know where.
Because he's looking at.
Maybe it's because it's.
He's looking at the Flemish one.
I'm looking at the Dutch one. Maybe in French they're much more open about what they're doing.
Maybe it's your Israeli
IP
Israeli
address.
That might be. Yeah. You're from Israel. Well, you don't care about this.
I see. No, from the U.S. If you go in.
By the way, it goes back to what we talked about before. Do we have one unilateral cookie banner worldwide, or does it detect your IP address and give you a different banner depending on your jurisdiction?
Yeah, but it does explain what cookies are generally.
No, it's each cookie. And
I'm not sure it's about their.
Now you're reading Flemish too?
No, I have it in English. I saw the same place. But look at the list, right? So it's name, what is it, data?
By the way, you can screen it on the...
Yeah, okay, so the interesting thing is...
It's not in their banner.
The banner basically blocks much of the text that you want to read.
Yeah.
Because it won't go away.
So I don't get the banner, but their banner
the banner is certainly not compliant because it just says, okay, I agree, I don't want analytics, and then settings.
So then, so basically, right, through the banner, you're able to access the disclosure, and the disclosure is complete. So that, I think, is an interesting discussion. Where should the list be? It's in the banner, it's in the cookie notice, it's whatever. But it's a different issue, right? The banner is supposed to be the gate, and the transparency.
And it should work, by the way.
I have a question. Most of the privacy vendors provide cookies, the explicit cookie consent. Most of them do not display the specific cookies that the company is using. Some of them go with a list of third-party services, for example, Google Analytics and so on. So do not list all the specific cookies.
It depends on the jurisdiction, but if it's in the EU, it's problematic.
The ones that I've seen have. I think that some of them sort them by vendor, and then it's vendor, 3 cookies, vendor, 3 cookies. No idea why that's good. But all the ones that I've seen, there is some way to get at the list of cookies. Some of them don't have the retention term. I've seen different issues with the retention of the cookies, which I think is going to be a problem because I think in the US you're going to need to do it. But I don't know, the ones that I've seen have it. But I think
doesn't do
Well, so that's the other thing is that, you know, especially pursuant to the Sephora decision, where Sephora had a cookie management provider that will not be named, but they had a cookie management provider. Cookie management provider did not, first of all, didn't recognize global privacy controls, which is a browser-based signal that you also have to recognize in the US, which is a different type of issue. But they had a provider. The provider didn't opt them. You clicked opt out of sale. You clicked do not sell. It opted you out of a bunch of cookies like Google Analytics and whatever. It did not opt you out of Adobe Analytics. That was a sale. California Attorney General went to Sephora and said, guys, Adobe Analytics in the sale. And at that point, Sephora did something that you know, it's like Helen said, that's a question. They said, no, it's not. And the regulator was like, oh, okay, we're going to sue you. So then they went to court, and they debated whether or not Adobe Analytics was a sale. They lost.
Well, what was the sale?
Adobe Analytics was considered to be a controller-to-controller transfer. The use of the analytics.
Okay, because they were using it for their own purposes.
Yeah. So they said this isn't a sale, it's a service provider, and the Attorney General said, no, it's not, it's a sale. It's a sale. And also, there were two things. So they didn't get opted out, and that is a $1.2 million fine. So the first maybe this Cian is gonna be happy with this conclusion. First, conclusion number one: the regulator tells you this is something you may want to consider, and not saying no, it's not. That may be one practice point. But also the other one, in this we have FTC enforcement and the California Attorney General. They didn't check. This is actually really easy.
So the cookie banner works.
Yeah, if you click opt out or reject all or do not sell, there is a very easy tech way to figure out this actually works. And the FTC expects you to do it, and California fines you if you don't do it. So I feel like they expect you to do it also. It's very easy to figure out. If you click and it's the same as, and there are people in California sitting, and there are, I think, people definitely annoyed. People are sitting, clicking banners, and figuring out if it's actually working on the back end. There are people that do this. So you should do that for yourself also.
And the European Data Protection Board has just organised training for all regulators and DPA around examining websites as well. So we're definitely skilling up in this area.
So the person, the grunt people that just got hired, that's their first first task of business. Yeah. Here's a tool. Start clicking.
Review 100 websites now.
Plus, for Israel, of course, but also US, I'm sure, and Europe. Even if you didn't have to do it in the first place, if you tell someone, click here and we won't use cookies, and then you do, then that is consumer deception, yeah. And you will be sued in Israel in a class action, right? Really? Okay, so that's, you made your own problem, you created it, now you pay the price.
Wow. By the way, it's going back again to the transparency and the need for the privacy notices, private cookie policies, and so forth to be accurate and to say what you're actually doing. And specifically in Israel, where the legal basis is consent, it's easy. Just list what you're doing. List what you're collecting. List what you're using it for. And we always find this when we interview new clients, where they tell us, yeah, this is a product, but we intend to do this, and we might do that. And then we tell them, we don't care.
Can we keep
tell us what you're doing now.
We can keep our options open? No.
Yeah. Exactly. No. So tell us what you're doing now, what you're collecting now, and be conscious that you need to contact us. And as you said, cookies are changing. Also, other privacy practices are changing. You need to be in constant review and amendment of these disclosures, because that's the basis of the data you're collecting in order not to contaminate your data.
And it may not even, because I get asked this all the time, but what if let's just keep it vague, because what if we want to do it next year? Number one, you're not allowed to be vague. There's a bunch of FTC decisions that specifically call out, just like the DPC decision, not this Meta one, the one from last year. The WhatsApp one. Don't use may, right? There is the statements in the US and in the DPC decision. Don't use the word may. The word may is a problem, right? Like, don't be vague. That's already a transparency violation. But it's even worse than that. You say may, and then you change the but what if you want to get something else? But if you want to do something else that's different from the now, you need to get the actual consent. In the U.S., by the way, we have, those of you that are, like deep into GDPR, the changing the incompatible purpose thing, right? If you're using it for an incompatible purpose, you change your purpose. under GDPR, you need a new legal basis, right? So you
Same
can't
in
just do
Israel.
it, right? Under under California and Colorado, you need actual GDPR Article 7 consent. It's even more strict than 6.4. You actually need consent. So if you need consent for your new thing, you can't just do it later and just figure it out. So you've got to actually reconsent the people. You can't do it retroactively. So it doesn't help. One, you can't do it because it's not correct and it's incorrect and there's decisions on that. But two, if you change your practice, you actually have to get consent. There is the FTC decision on Twitter. That's what it is. Twitter with the phone, two-factor authentication. Twitter collected mobile phone numbers, said this is for security purpose only, used it for retargeting, and got a huge FTC fine. And the FTC says if you're doing something and you want to do something completely different, saying that in line 47 of your terms of use is not consent. You can't do it. This is not. You need to reconsent the people. You can't use it retroactively. I mean, you may be able to, even in the US, be able to change your terms of use or whatever and say we've changed our notice, and going forward, you may be able to use it for that new purpose. But you can't retroactively change your notice and suddenly all of the phone numbers that you collected under the previous notice now use them for targeting, right? Also, don't use phone numbers for targeting. If people don't know, it's a bad idea. Don't use them, period.
Shocking. Shocking.
Key takeaway from the session, don't lie. Like, this is,
And be accurate.
Shocking. Like,
Thank you, everybody.
Thank you.